So we are continuing with our discussion of National Law School, and the last time we discussed up to the end of St. Thomas Aquinas, and we would like to continue with Hugo Grotius. Hugo Grotius lived in the 16th to 17th century. He was a Dutch jurist who is said to have laid the foundation for what we call international law. Now, his foundation for international law was based on natural law thinking. So, as we know, we have municipal law, national or domestic laws of various countries, and when they come together on the international plane or arena, we have international law. So he held the view that the international law was superior to municipal law in a sense. Now, Grotius is normally associated with inauguration of a secular natural law thinking. Secular natural law thinking in the sense that trying to understand natural law not necessarily through the lenses of religion or religious thought. So that is what we mean by saying that Grotius is associated with secular law or secularization of natural law thinking. His writings actually influence political, social contract philosophies of Thomas Hobbes, Locke, and Rousseau. And later on, those ideas will become catalysts in giving stimulus or impetus to the revolutions which we witnessed in France and then the United States. And as we have noted, Grotius actually influence what we also call the international law today. And his main concern was to establish a system of international law to regulate the affairs and warfare of the rising nation states. Because at this time, the idea of modern nation states were quite relevant. A lot of states were emerging. And in Grotius' view, a precondition of such a system is stable, orderly government within nations. And for that matter, he saw government as resting on social contracts, and that the people surrounding their freedom for security. So there's a social contract between government and people. You surrender your freedom so that the state will provide you security. Now, when Grotius did that, he advocated that once you have actually surrounded your freedom and the state providing security, then they should lack the right of repudiating the sovereign. You should not be able to say that you are no longer going to submit to the authority of the state or the sovereign, however unjust the laws he makes. And now, on that basis, it becomes a bit difficult to try and reconcile uh, you know, what Grotius actually, advocated in this regard with, that is trying to ensure stability, right, in the state. That once the state has come into being, people have surrendered their freedom in return for security. Then that is it. They should never be able to say that they are repudiating that arrangement and they will no longer submit, because he was interested in stability. And he said that that should be so, even if the sovereign made unjust laws. But that appears somehow no, difficult or contradictory with the precepts of natural law he advocates. And it is further complicated in the sense that sovereigns are also bound by natural law. Now, Grotius, aside his teaching on the social contracts between the governed and the sovereign, in expanding his views on natural law, regarded certain things as intrinsically wrong, whether or not it had been decreed by God. In other words, in Grotius' thinking, whether a thing is right or wrong is not to be determined by divine fiat, but by its natural appropriateness. So Grotius places emphasis on the natural reason of man. And that is why Grotius will go as far as to make the point that we should be able to think of natural law, even if we did not look at it from the point of view of God. And he said natural law will subsist even if God did not exist. Etiamsi, daremus, non esse Deum. That natural law will exist even if God did not exist. Mind you, he's not saying that God does not exist, okay? He doesn't say that God does not exist. He's only saying that it is possible for us to entertain natural law thinking in the most extreme case, that even if God did not exist. So, etiamsi daremus, non esse Deum. Natural law will subsist even if God did not exist. So, assuming in examination, I write, natural law will exist even if God did not exist. Etiamsi daremus non esse Deum. Hugo Grotius critically comment on this. You should be able to do it. And we will now like to look at the social contract within the natural law frame. So we have people who develop the thinking that Grotius started, which we've been talking about. So we have what we call like the social contractarians, those who sought to provide an explanation regarding the existence of state and the obligation of obedience or loyalty or allegiance, which citizens or subjects should render to the states. So we have Thomas Hobbes. He will tell us that laws of nature are rational strategies for peace, and that authority arises from covenant to escape the state of war. And later on, we will be told that in Hobbes' thinking, in the state of nature, there was man was at war against one another. Life was quite precarious and so on. So it was necessary for them to surrender their freedom, as it were, to the central state in return for security, in return for peace. And John Locke would also talk about natural rights, and he said that natural rights constrain government. That is to say that there are certain rights which are innate to us as human beings, and by reason of that, they serve as a check or limitation on the powers of government. So therefore, authority is fiduciary. It's fiduciary and revocable. When it says that authority is fiduciary, you've done the company law and so on, and agency law. That is to say that it's based upon trust and confidence. The governed, the subjects or the citizenry, they have entrusted authority to the governor, and it is expected that the power will not be abused. It will be used in good faith for the welfare of the governed. And that is why Locke is of the view that under appropriate circumstances, the authority given to government should be revocable. You should be able to, like as it were, sack the government or withdraw the authority. So he will tell us that resistance is justified when trust is betrayed. It is permissible for the governed to rise against the governor or the government or the state, where those in charge conduct themselves in a way which suggests that they have broken the trust. And Lloyd Jurisprudence, the editors, the MDA Freeman, would remind us that John Locke seemed to have made a shift from consent to trust. That is to say that it's not just enough to say that we have given our consent to it and so be it. No, we have also put our trust in you as a government, and that should serve as a check on you. And that thinking actually resonates or reflects what we call constitutionalism in modern constitutional law. So constitutionalism is nothing more than the idea that when it comes to governance, there should be limitations, there should be restrictions on those who exercise the power of governance. And the limitations or the restrictions are meant to actually safeguard the liberty of the governed. Now let's take each of these social contrarians and expand their own contribution to natural law thinking from the social contract perspective. Now, Thomas Hobbes, who also lived in the 16th to the 17th century, propounded a social contract theory based on the premise that man's basic instinct was that of self-preservation. In other words, the primordial quest, that which drives every human being, is to preserve himself or herself from destruction. And that is why we often say that self-preservation is the first law of what? Of nature. And when I was in the physical classroom, I told you that assuming someone said, "Oh, there's fire in the room," as soon as you hear that danger, instinctively you will seek to get out of that danger. And you do that first before you even begin to remember. If you have like a twin brother or sister in the classroom, as whether he or she is also safe. Because there's that basic instinct in us for self-preservation. And for that matter, Hobbes holds the view that man has a natural right to self-preservation. Because of this basic instinct, then we have the natural right to self-preservation. And he observed that before the formation of the social contract, man was in a state of nature, if you like, the original state. And in that state of nature, Hobbes points out that it was a state characterized by internecine warfare, continuous warfare, where life was nasty, brutish, and short. So life was really rough because everyone was at war against the other. And in order to preserve his man, this social contract came about by which man or the individual will surrender his natural freedom to a sovereign to form an orderly society. And Hobbes reminds us that it is because of this that law and government becomes necessary. So law and government are needed for the reason that the individual surrendered his freedom to the state, for the state to provide security, as it were, protection. So law and state arrangements are utilized in order to actualize or to fulfill this social contract. So every citizen thus become politically obligated to the sovereign. So obedience to the state, obedience to the sovereign is then not an ordinary choice, but it's obligatory. All must obey the sovereign as a prerequisite for justice. And in that regard, Hobbes postulates that there cannot be an unjust law emanating from the sovereign. And it is only when the sovereign cannot guarantee the preservation of the citizen that the obligation to obey law ceases. So look at it. Look at the angle Hobbes is coming from. Hobbes is saying that when the sovereign has made the law, there should be no question of whether it being just or unjust. The sovereign must be obeyed at all times. The only caveat is that where the sovereign loses the ability to preserve or protect citizens, then the citizens do not have obligation to obey the sovereign and his law. Because the reason why the state arrangements came into being is for us to surrender our freedom so that the state is able to organize and provide security or protection for us. However, if that is not forthcoming, if the state is unable to do that, then what is the legitimacy for us to remain in that pact, that arrangement, that contract? And that is why Hobbes is trying to use the ability, continuing ability of the sovereign or the state to provide security, to provide protection for the governed as the most important yardstick in trying to evaluate whether the citizenry or the subjects are still supposed to obey laws and the institutions of the state. So Thomas Hobbes characterized peace, which man desired, as a consequence of the need for self-preservation, as the first law of nature. So the first law of nature is self-preservation, and it finds practical expression in the quest for peace. So, therefore, the mutual divesting of individual rights to the sovereign, that is, I have a right, you have a right, we freely surrendering that to the sovereign, to the state, is the second law of nature. And then the third law, according to Hobbes, is the need to respect contracts voluntarily entered into. So we have pacta sunt servanda, sanctity of contract, and so on. Contracts must be upheld or obeyed. So look at this schema, starting that the first precept of natural law is self-preservation. That's the first law of nature. And this finds practical expression in our need for peace. And he said that following from that, then we mutually surrender our rights to the sovereign or the state. And the third law of nature for him will be that the contract which has been made between the citizenry and then the governed or the sovereign should be respected. And for him, when you put these things together, they constitute morality, which is arrived at through social contract. So let us keep that in mind. And we move on to John Locke. Locke is another social contractarian, and his version of the social contract theory also focus on the concept of natural rights. And by this, it means what rights and duties men have as creatures of God in the state of nature. So before we came to have like the modern state, in the state of nature, what rights did human beings have? So unlike Thomas Hobbes, John Locke premised his theory on the ownership of property acquired by missing labor, or the free gift of earth, which God has given to all. And for him, this was the prime value of morality. So look at it. Those of you who do an intellectual property law, land law, law and economics analysis, you have come across this point we are making, that for Locke, in the state of nature, everybody is on his own, and if you are able to exert your strength, mix your labor with nature, you're able to get property out of it. And once you get the property by your own sweat, you should be able to enjoy it or hold on to it yourself without anybody taking it away from you. Maybe, probably, if you come to our customary land law, I think we all remember the usufructuary interest or the customary law freehold, which works like this, that you are a member of the Alodia holding family, Alodia title holding family, and at customary law, you could cultivate any portion of the land which is not already cultivated or occupied by another person, so long as you're a member of the Alodia family. And you could cultivate up to wherever your machete or your cutlass could take you to. And once you did that, ordinarily speaking, that became a sort of like a property for you, and it will not be taken away from you. In the same vein, Locke is saying that in the state of nature, people are able to exert themselves, apply their strength, and appropriate part of nature to themselves, and that becomes their property. Now, Locke makes the point that the state of nature was one of pure bliss. It was like a happy state, unlike Thomas Hobbes. Thomas Hobbes told us that the state of nature was really horrible. It was nasty, brutish, and short because every man was at war against the other. But in John Locke's version of the state of nature, before the social contract was made, in Lockean version, it was a pure bliss. Everything was sweet and happy. But there was one inadequacy. There was one shortcoming in John Locke's version of the state of nature. And what was that inadequacy? That has to do with the fact that property was insecure. That where people have actually worked hard to acquire property, other people who were stronger could actually dispossess you of your property or take over your property. And that was a big problem. So that was, if you like, the most important problem in Locke's version of the state of nature. Despite the fact that everything was happy and sweet, people did not feel a sense of security for their property. The fear that those who were stronger than them could actually take it over from them. So that was that challenge. And to remedy this inadequacy, to remedy this problem in Locke's version of the state of nature, man gives up his freedom to a sovereign. So look at it. The singular motivation for man surrounding his freedom to the sovereign within John Locke's version of social contract is to enable the sovereign to give security to man's property, as it were. Therefore, law and government exist in John Locke's thinking to secure the natural rights of the individual. And the natural rights of the individual, as we have explained, include ownership of property, where you have been able to mix your sweat with nature. So, foremost among these natural rights is the right to hold other men responsible for breaches of the natural rights of others, so that if another person seeks to breach my natural right, either to life or to own property, we should be able to hold those violators accountable or responsible. So the citizen must obey both law and government, so long as it is capable of preserving its natural rights by holding others responsible for such breaches. So that is very important. And that is why in Lockean thinking, if the state system, for example, is not able to ensure law and order, and we just have a situation of impunity, people continue to commit violations of the law and they are not held accountable, then it's evidence that the state system is not working. I just want to take a line or two from one of John Locke's writing. It has been accepted for us in the Locke's Jurisprudence. So one of his work, the two treatises of government, John Locke wrote as follows, and I quote, "But though this be a state of liberty, yet it is not a state of license, though man in that state have an uncontrollable liberty to dispose of his person or possessions, yet he has not liberty to destroy himself, or so much as any creature in his possession, but where some nobler use than its bare preservation calls for it. The state of nature has a law of nature to govern it, which obliges everyone a reason, which is that law teaches all mankind who will but consult it, that being all equal and independent, no one ought to harm another in his life, health, liberty, or possession. For men, being all the workmanship of one omnipotent and infinitely wise maker, all the servants of one sovereign master, sent into the world by his order and about his business, they are his property, whose workmanship they are made, to last during his not one another's pleasure." Then he will continue in another part of his work, quote, "Man being born as has been proved with the title to perfect freedom and an uncontrolled enjoyment of all the rights and privileges of the law of nature, equally with any other man or number of men in the world, had by nature a power not only to preserve his property, that is, his life, liberty, and estate, against the injuries and attempts of other men, but to judge of and punish the breaches of that law in others, as he is persuaded the offense deserves, even with death itself, in crimes where the heinousness of the fact, in his opinion, requires it. But because no political society can be nor subsist without having in itself the power to preserve the property, and in order thereon to punish the offenses of all those of that society. There, and there only, is political society, where every one of the members had quitted his natural power, resigned it up into the hands of the community in all cases. That excludes him not from appealing for protection to law established by it. So just trying to explain the basis for the existence of law and criminal law and so on to ensure protection of everyone in the society. We will look at another scholar, J.J. Rousseau, Jean-Jacques Rousseau. He also lived in the 18th century and also made important contribution to social contract thinking. And he also did a work, and he called the work the social contract. And he said that we must always go back to an original compact, the original agreement which we made before the state came into being. Now, Rousseau's version of social contract emphasized the concept of general will. The concept of general will. So to Rousseau, the social contract was the way by which the individual merges into the life of the community and become part of the general will. So trying to say that, yes, as individuals, we have our individual wills, but by reason of social contracts, we become part of the larger community. And once we are part of the larger community, it is as if we have aggregated, we have put together our individual will so as to get the community will. And that makes the community will, or what we call it, the general will, superior to our individual will, because it's all of us, our individual wills, which we have surrendered and come together in that regard. Therefore, law and government becomes the register of the general will and can only be tolerated so long as it accurately reflects the general will. So law is supposed to mirror, advance the general will, and as we have noted, the general will is supposed to be more or less the aggregation of our individual will once we have come together to live in the society. Then, so he will say this. Let me quote a line from his work. J.J. Rousseau speaking from his original work, quote, "No matter how many isolated individuals may submit to the enforced control of a single conqueror, the resulting relationship will ever be that of master and slave, never of people and ruler. The body of men so controlled may be an agglomeration. It is not an association. It implies neither public welfare nor a body politic. An individual may conquer half the world, but he is still only an individual. His interests, wholly different from those of the subjects, are private to himself. When he dies, his empire is left scattered and disintegrated. He is like an oak which crumbles and collapses in ashes so soon as the fire consumes it." Then he continues, "A people, says Grotius, may give themselves to a king. His argument implies that the said people were already a people before this act of surrender. The very act of gift was that of a political group and presupposed public deliberation. Before, therefore, we consider the act by which a people is constituted as their kin, it were well if we consider the act by which a people chooses such, for it necessarily precedes the other, and is the true foundation on which all societies rest. Had there been no original compact, why, unless the choice were unanimous, should the minority ever have agreed to accept the decision of the majority? So Rousseau is just trying to remind us that however we look at things, before we came to have the modern state, we came to have the arrangements under which we live. We had the initial compact or agreement. And to Rousseau, the general will which come out of that contact is characterized by popular sovereignty. And it is this popular sovereignty which determines what is good what is good for society as a whole. So it is that popular sovereignty which determines it. And this replaces the higher law standard which natural law represents. So you see that Rousseau is trying to bring natural law thinking home and says that yes, popular sovereignty is based upon the general will, and the popular sovereignty should determine what is good for society as a whole. Now, if we are to link that thinking to constitutional law in Ghana, okay, you will notice that there is a provision in our constitution. I'll just give you just one or two instantiations. So take Article 1, Clause 1 of the Constitution. Quote, the sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government are to be exercised in the manner and within the limits laid down in this Constitution. So similar to what Rousseau is talking about, that the sovereignty of Ghana is from we the people. And for that matter, we have given it to whoever is going to constitute the government. And it should be exercised in a way which will advance our welfare according to the parameters of the Constitution. But there is another thing I propose for your consideration. What we call the public interest. Because Rousseau is saying that what determines what is good for society as a whole is the popular sovereignty, which is based upon general will. So in our constitutional establishment, how does this play out? I propose for your consideration Article 295 of the Constitution, the interpretation provision of the 1992 Constitution. If we go to Article 295, Clause 1, look at public interest, and this is how it's explained. Public interest includes any right or advantage which inures or is intended to inure to the benefit generally of the whole of the people of Ghana. And the question is, who determines whether something inures to the benefit of the whole of the people of Ghana? It is certainly those who have been elected to be in charge of the government from time to time, as the case may be. And that is why if you look at Article 58 of the Constitution, for example, we are told that the executive authority of Ghana shall vest in the president. And the executive authority here, we're talking about the government. And so the government will determine what is in the public interest. And that is why people campaign, they have their manifestos, and they get elected. And then once they are elected, they actually will make the necessary determination that we should build more roads, we should do this or we should do that, because in their thinking, that is what is in the public interest. And so they have been elected, and legitimately so, within the concept of democratic legitimacy. Whoever is elected will be entitled to make such determinations. We also have another scholar known as Rudolf Stammeler. Rudolf Stammeler, and he also made some useful contribution towards natural law thinking. Now, Stammeler was a German jurist who was concerned with the formulation of the right law based on justice. So how can we have a right law based on justice? So Stammeler developed the idea of a natural law with a variable content. And that is another difficulty. So he was talking about the fact that, yes, we can have a right law based upon justice, but the content of natural law will not be the same everywhere. Drink water. So Stammeler developed the idea of a natural law with a variable content. And what does that mean? Mind you, when we started, we have pointed out that natural law, talk about principles which are supposed to be immutable, unchangeable, meaning that it's eternal, always valid. And two, it's universal. It's everywhere the same. No wonder Cicero will tell us that the law will not be one at Athens and another at Rome. It's everywhere the same, as it were. But Rudolf Stammeler says that it is not always correct for us to expect that natural law will be the same everywhere. So his theory is premised on the fact that each era, each period or generation has its own right law. And this should coexist with positive law. It is not the law of nature, but the nature of law which was common to man everywhere. So that is a very fundamental statement. So Stammeler is saying that we shouldn't just be talking about the law of nature being applicable to everyone everywhere, but more importantly, it is the nature of law which is common to man everywhere. So by thinking this way, in Stamler's mind, the content of natural law is variable in the sense that the standards by which positive law, man-made law, is judged or evaluated varies with time, and it is dependent on the prevalent ethical and philosophical doctrine of the time. So the standards of natural law are not immutable. So going by Stamler thinking, the principles of natural law are changeable. They are not unchangeable. And the reason for postulating that viewpoint is that society is in flux. That is, society is not static. Society keeps changing. Society keeps changing. As a Christian hymn will say, through all the changing seasons of what? Of life. So it's not static. There are changes every now and again. So Stamler will give example that, like principles of justice, for example, maybe such as respect for human dignity and equality, are universal. That is, they are applicable everywhere and are constant. However, specific arrangements for actualizing that or for expressing those principles are not static. They must evolve with changing social, economic, and cultural realities. I'll give you an example. The Supreme Court, if you look at our Constitution, our Constitution has a provision on what we call the spousal property right, as it were. Property rights as far Article 22, okay? And Article 22 one says that a spouse shall not be deprived of a reasonable provision out of the estate of a spouse, whether or not the spouse died, having made a will. Then clause 2, Parliament shall, as soon as practicable, after the coming into force of this Constitution, enact legislation regulating property rights of what? Of spouses. And then clause 3 will say that with a view to achieving the full realization of the rights referred to in clause 2 of this article, spouses shall have equal access to property jointly acquired during marriage. Assets which are jointly acquired during marriage shall be distributed equitably between the spouses upon dissolution of the marriage. Good. Now, from various jurisprudence or case law, mensa and mensa, fin and fin, and so on, that because Parliament has not enacted this spousal property legislation, the courts have had to come in to try and provide a formula which should be used in distributing property between spouses upon dissolution of the marriage or something like that. And the thinking for a long time used to be having numerical, 50-50. But then, if we look at the two Supreme Court decisions, which came out this year, one in March, one in July, late opinions by Justice Tanko and Justice Esse. The gravamen of their thinking, as reflected in those cases, is that we need to have a flexible contextual approach in determining how spatial properties should be what? Should be distributed, or how it should be determined whether a property is jointly acquired. And if it's jointly acquired, does it automatically means that they have to be shared 50-50 and so on? Previously, for a long time, when Mensa and the rest were decided, the thinking used to be like, numerical 50-50, that equality or equity means equality, equality means equity, and that was translated into 50-50. But in more recent jurisprudence, the court is telling us that not necessarily so. So if you are interested, you can read the case of Aishetu Abdul Kadiri against Abdul Yamina. You can get it from the Danish law website. Or you can also look at the other case, Pokua against Kwachi. Pokua against Kwachi. Now let's move on to Lomfula. Lomfula is a very important scholar. I will share one of his original work, what he titled The Morality of Law with you. If you make effort to read it, if you can, to deepen your understanding of the subject. Professor Lomfula is a very important contributor. He was an American professor of jurisprudence at Harvard University and is regarded as a leading contemporary natural law theorist. Now, his theory or his contribution to natural law lacked metaphysical structure of natural law. His approach is focusing on what we call procedural natural law, if you like, rather than substantive natural law. What do we mean by that? Fuller sought to explain the moral content in the idea of rule of law. So when we say like rule of law, like in Ghana, for example, our constitution, if we take the preamble, rule of law is mentioned as one of the pillars or one of the underlying values or principles of our constitutional setup. You talk about governance by rules and judicial institutions. And he was not so much concerned with analysis of substantive content of legal rules. No. So as far as Lomfula was concerned, reason played a role in legal ordering or arrangements. And what did he mean by this? To Fuller, this reason consists of discovering those principles of social order which will enable man to attain a satisfactory life in common, a worldwide life in common. In other words, Fuller was of the view that human beings, we have ends, we have purposes, we have teleos, right? We have ends, purposes of teleos. And what is that end? The attainment of a satisfactory life, a happy life, a good life, as it were. And if that was the purpose, if that was the telos, the end, we needed the means to reach that end. And the means to reach that end will be rules or the law which we make. So we cannot really judge the ends or purposes as having been attained without being concerned about the nature or quality of the means, like the rules, which are supposed to enable us to achieve those ends or those purposes. So Fuller applied this reasoning approach to the process of legislation or lawmaking. And in that regard, Fuller sought to show that the process of legislation was governed by objectively determinable laws, which were natural. These objectively determinable laws or principles were natural. And to him, these are the goals which a legal system must achieve to qualify as a system of law. So for a legal system to qualify as a system of law, it must actually reflect these objectively determinable laws. So what are the goals which a legal system must achieve? So the goals which a legal system must achieve were actually formulated by Fuller in his work, The Morality of Law, after he has used a very interesting allegory. And I would love to have all of you to read this. And the essential extract, even if you don't read like the whole of his work, have been extracted for us in the law jurisprudence. So before we come to talk about the goals which a legal system should reflect, or Fuller's blueprint, let's remind ourselves of what Fuller did. Fuller, in his work, The Morality of Law, sought to tell a story of an unhappy king or the unhappy reign of a monarch. And he used his frustrations to demonstrate bad examples of lawmaking, and out of which he will proceed to try and identify what he called the goals of a legal system. So according to Fuller, there was a king. He used the Latin word rex, R-E-X, who came to the throne. And when he came to the throne, he had so much enthusiasm to reform the system. And this new king held the view that his predecessor, that is those he came to succeed, their greatest failure during their reign has been in the field of law. And to the mind of this king, for a long time, the legal system or the institution has not seen any reform. So he said that when it comes to trial, the procedures were cumbersome. The rules of law spoke in archaic tongue of another age. Justice was expensive. Judges were sometimes corrupt. So the king or Res was determined to remedy all these problems and to make his name in history as the great lawgiver. Unfortunately, he did not succeed, as we see. What did he do first, this new king? His first official act was very dramatic. He said that he needed a clean slate to get his reforms unleashed. So what did he do? He made an announcement to his subject that with immediate effect, he has repealed or cancelled or abolished all laws of whatever kind, because he said that he needed to get like a fresh start to be able to get his reforms implemented. Now, having abolished all existing law, both substantive procedure, everything, this new king set about drafting a new code. Unfortunately, he didn't have training in how to draft law because that was not his training, just a prince. So what happened was that he couldn't make generalization, and he rather decided to try and prescribe every detailed rule. But that was also not sustainable. So in the course of time, this king became aware of his limitation or his deficiency. So he abandoned the project of writing a code and made announcement to his subjects that henceforth he himself will act as a judge in any dispute that might arise from them. And he thought that by sitting as a judge to resolve all disputes, it will enable him to develop his latent powers of generalization as he will be working on case by case. But unfortunately, he did not also succeed, because after giving some number of decisions, he himself lost track, and then his citizens could also not actually follow whatever principle he was trying to lay in those cases. So there was confusion, which compounded everything. So after this failure or fiasco, this king or Res saw the need for another fresh start. What did he do? His first move was to try and go to school and learn how to do generalization. So having undertaken this course, he resumed the project of writing a code. And eventually, he got a lengthy document written as a code. But he was still not satisfied. And he made an announcement that the code would remain a state secret, which will be kept by him. And when there are cases, he will look at it and use it to decide the cases. But the subjects resented this announcement by the king because for them, it was quite unpleasant to have one's case decided by rules when there was no way of knowing what those rules were. So there's no transparency. So just imagine you went to the court and then the judge listened to your case. And after listening to you, just say that, okay, you the plaintiff, you are right. The defendant, you are wrong. And no law is actually used to explain why that is the case. And you also didn't know the law ahead of time. Will you be happy? So that was the situation with the subjects of this new king. So he was worried about this protest by his subjects. So he decided to do self-introspection, try and take an account of his own life. What are my weaknesses? What are my strengths? And of course, as human beings, we also need to do that. Nobody is perfect. Nobody is superhuman. We have our flaws. So the king decided to do that self-introspection. And he took the view that life had taught him one clear lesson. That is, it is easier to decide things with the aid of hindsight than it is attempt to foresee and control the future. So, this new king decided to make use of this hindsight approach. And he came out with a plan. At the beginning of each calendar year, he will decide all controversies that had arisen among his subjects during the preceding year, the year before. And he will accompany his decisions with a full statement of reasons. So he announced this new plan to his subjects. And he said that he was going to publish full text of his judgments with rules applied by him. And for that matter, that will meet the objection which his subjects had to his earlier plan. But this plan also did not work out well. So he decided to get legal experts to revise his code, which he had made. But the code was also very detailed that it was difficult to even remember things which are in the code. And there was another uproar among the people. And the king was forced to withdraw the code from the system. Then he decided to let another revision be done to the code. And among other things, he came out with a very severe punishment for certain behaviors in the code. For example, he decided to teach his subjects a lesson and put an end to their rebellious behavior. So he instructed his experts to purge the code of contradictions, but at the same time to stiffen the punishment for the various crimes. So, for example, previously, citizens summoned to the throne was given 10 days in which to report to the king. In the revision, the time was cut to 10 seconds. So 10 seconds, if you are summoned by the king and you are not there, you've breached the law. And was made a crime punishable by 10 years imprisonment. To cough or sneeze or hiccough, faint or fall down in the presence of the king. It was also made a treason not to understand or believe in or correctly profess the doctrine of evolutionary democratic redemption. So these were some of the new things in the revised code. Now, when this new code was published, there was a near revolution which erupted among the people. And leading citizens declared their intention to disobey the provisions. And someone even discovered in an ancient author passage which ran like this, quote, "To command what cannot be done is not to make law, it is to make law. For a command that cannot be obeyed serves no end but confusion, fear, and chaos," unquote. So, in no time, people were sending a lot of petitions to the king, and they were quoting this particular line as part of their petition. Now, the king came under pressure and eventually withdrew this code. Now, the point being made is that he tried so many things, and they all failed. Now, Lomfula uses this experiment by this new king to teach us an important lesson, the lesson of what he calls the inner morality of law. So based upon these failures, he tries to propound the good principles which should inform every legal system. And these are that there should be rules in the first place as opposed to series of ad hoc judgments. So, in a legal system, the rules should be known, not just ad hoc judgment like what the king was trying to do. And two, the rules must be made public or known to all those affected by them. People should know the rules. It shouldn't mean the case that the rules are actually held, in somebody's pocket or bedroom, and he alone knows it. No. And that is why in our constitution, we even have a requirement of publication of the laws. They should be gazetted. If you go to Article 106, it should be gazetted. If you go to Article 11, Clause 7, even statutory legislation or regulated legislation also be gazetted. And the point of this gazetting is to make the citizenry aware that these laws are in force. 3, the rules should not have a retrospective effect. You cannot make a law saying that what somebody did yesterday is illegal, when the thing has already taken place and the person does not have the opportunity to actually undo that which he did yesterday. So that is certainly not right. And for that matter, a legal system should not do that. And indeed, if you look at our own constitution, you know that we have part of the presumption of fair trial, that you cannot actually be convicted of, or you cannot be tried, under a law which does not exist at the time that you conducted yourself. And then the principle of legality also means that the law should have actually defined the particular conduct for which you are being tried before and not after you have actually committed the conduct, and then a law is made to make illegal that which you have already done. That is not right. So if you look at Code 19 clause 5, that a person shall not be charged with or held to be guilty of criminal offense which is founded on an act or omission that did not at the time it took place constitute an offense. So there's that constitutional prohibition of retrospectivity and also retroactivity as well. 4, the rules should be understandable. We noted that at some point this new king was frustrated, his citizens were also frustrated because they could not understand the rules which were made. And of course, rules are supposed to serve the interests of governance, the citizenry. So if they do not understand it, how can they be governed by it? 5, the rules should not be contradictory. The rules should not be contradictory, and that is why when it comes to interpretation, there's a presumption against contradiction, that the lawmaker is presumed to be consistent or coherent as the case may be. Then the rules should not require the impossible of the people. A rule should not create obligations which are not practical for human beings to actually meet. Look at the code where they revise the code and say that previously, if the king summoned, you had, let's say, 10 days to report. And when they changed that, they said that when the king summons, you must report in 10 seconds. Certainly, that is not practical. So the rules should not require the impossible of the people. Again, the rules should not be subject to frequent or arbitrary change. Where rules are subject to frequent or arbitrary change, it becomes difficult for people to even remain up to date, for people to keep track. And then again, there's also no problem with consistency. Then the rules as announced should coincide with the actual administration of the rules. It shouldn't be the case that the rules as made is one thing, and then when it comes to application of the law, we do something else. No. It is the rules as made which should be actually applied and not something else. So in Longfuller's view, these conditions actually constitute morality and makes the law possible. And for him, this morality is internal to the law itself. It's not external. So unlike what some other natural law scholars says that there are higher principles out there to which man-made laws should approximate or reflect. Fuller is telling us that these principles are internal to the law itself. And that is why he called them the inner morality of law. So let's ask ourselves, these principles or these goals or conditions which Fuller say should be reflected in legal system, are they not self-evident? In other words, can we honestly disagree that these are not legitimate goals which a legal system should reflect? And that is why he says that they are very internal to the law itself. And for that matter, that is the inner morality of law. And if you have a law which does not reflect that, then there's a question mark as to whether it is worth meeting the status or the criterion of law. We also have another scholar, John Finnis. John Finnis is very important scholar because in the more recent, like contemporary times, he has given us a very compendious or comprehensive restatement or recalibration of our understanding of natural law. John Finnis did a very important work, Natural Law and Natural Rights. And in his work, Natural Law and Natural Rights, he had actually been influenced by the writings of Aristotle, who propounded the teleological ideas. Teleological, that is the fact that human beings, we have purpose, we have teleos, and also Aquinas. How Aquinas also sought to integrate the reason-based natural law and then God-based natural law, how he sought to integrate that. So, according to John Finnis, society has purposes and a significance which can only be achieved by an appropriate system of law. And finding an appropriate system is a concern for jurists. So look at his premises that society has purpose. We are not aimless, okay? We have a purpose and a certain significance. And this can be achieved or realized where we have the right system of law. And trying to find the right system of law which will enable us to achieve this purpose is the work of jurists. One of such purposes is human flourishing. That is, whatever constitutes a worthwhile and valuable life. So whatever constitutes a worthwhile and valuable life is what he means by human flourishing. And that is part of the purpose of society, purpose of human beings. So Finnis's theory has been characterized as the most authoritative modern restatement of natural law. According to Finnis, there are certain basic goods, and he says that they are irreducible, meaning that you cannot get anything which is more basic than that. You cannot get anything which is more basic than what he's talking about. So that's why I said that they are irreducible. And these basic goods are self-evident. Self-evident in the sense that every reasonable person must ascend to their values as object of human striving. That every reasonable person will agree that these are the things which human beings were legitimately about, which will enable us to realize our worthwhile as human beings. So what are these? What are the basic forms of the basic goods or the basic forms of good for us? So he talks about life. And by life, Finnis will say that a first basic value corresponding to the drive for self-preservation is the value of life. So here, when he talks about life, of course, without life, nothing is meaningful. If you and I are not alive today, we can't be having this discussion. We can't be going to school, we cannot be working or doing anything. But when he talks about life, he's talking about a very comprehensive aspect. So therefore, every aspect of vitality, every aspect of life, which puts human being in good shape for self-determination, is what it means by life. So in that case, life here includes bodily health, being strong physically, being strong mentally, and freedom from the pain that betokens organic malfunctioning or injury. So everything which enables our life to be optimal is what it means by life as a basic good. Of course, related to that, he will tell us is also uh, he made the point, let me quote him, and the recognition, pursuit, and realization of this basic human purpose are as various as the crafty struggle and prayer of man overboard, seeking to stay afloat until his ship turns back for him. The teamwork of surgeons and the whole network of supporting staff, ancillary services, medical schools, road safety laws and programs, famine relief expeditions, farming and railing and fishing, food marketing, resuscitation or suicide, washing out as one steps off the curb. So he's trying to make the point that this life, which is a basic good and derives from the first law of natural law, that is self-preservation. And he says that everything which let us remain alive, and not only remain alive, but to have what we call like the quality of life, to be able to exercise life functions and so on. They are all part of what it means by life as a basic good. So road safety laws to ensure that car will not come and kill you, to have a properly qualified health professionals to attend to you when you are sick, and so on and so forth. Procreation, your ability to know, give birth to other children so that the human race doesn't become extinct. They're all part of what it means by life. Then he also talks about knowledge. He said that the second basic value is knowledge. And by knowledge, he said that it is considered as desirable for its own sake, not instrumentality. So, knowledge here is not talking about maybe knowledge that you are seeking now. You are LLB students or you are law students. You want to get your qualification or you want to become a lawyer and so on. So, for you, in a sense, the knowledge that you are seeking now is not what he's talking about because your knowledge is more or less like instrumental knowledge. Without you, for example, getting this knowledge, you cannot become the lawyer you want to become, or you cannot go to the law school, as it were. But he is talking about knowledge which is good in itself. That is, you need to avoid ignorance. So you need to be well informed. So we often have the saying that it is the curiosity that kills the cat, isn't it? So that kind of curiosity is what this knowledge, to some extent, is also about. For you to actually overcome ignorance, to be well informed. And he also talks about play, play that is recreation, enjoyment or fun. That as human beings, we have the need for leisure, something we do other than work. And he talks about aesthetic experience, that as human beings, we have the capacity, the appreciation of beauty in art or nature. So you should be able to see something and say that this is beautiful, this is nice, or this is awesome, or this is ugly, or this is awful. Then sociability, friendship. So here, we often say that no man is an island. And we are told that we are no social beings. And we need to be at peace and harmony with one another. They are all forms of friendship. So, acting for sake of one's friend's purposes or the well-being of another, they're all part of the friendship or sociability. So, to be in a relationship or friendship with at least one other person is a fundamental form of good. Or do you disagree? Then he also talks about practical reasonableness. Practical reasonableness, that is employing one's intelligence to solve problems of deciding what to do, how to live, and shaping one's character. So when you use your intellect, your ability, faculties to be able to uh, become aware of your problems, strategize how to solve them, how to live, how to shape your character. They're all part of practical reasonableness. So, in his work, Finnis will put it this way, and I quote, "Sixthly, there is the basic good of being able to bring one's own intelligence to bear effectively in practical reasoning that issues in action on the problems of choosing one's actions and lifestyle and shaping one's own character. Then religion. So by religion too, uh, is talking about our concern with respect to another of things that transcends our individual interests. So that quest for transcendental encounter, there's something in us which seeks to let us connect with something outside us, outside like our human race, our human space. And that is religion. So in his work, Finnis will say that there is the value of what Saint Cicero will summarily call religion. For us, there is the order of means to ends in the pursuit of life, truth, play, and aesthetic experience in some individual selected order of priorities. An order that can be brought into human relations through collaboration, community, and friendship. And the order that is to be brought into one's character and activity through inner integrity and outer authenticity. So finally, there arises that question as A. How are all these orders, which have their immediate origin in human initiative and pass away in death, related to the lasting order of the whole cosmos and to the origin? And if any of that order be, is it not perhaps the case that human freedom, in which one rises above the determinism of instinct and impulse to an intelligent grasp of worthwhile forms of good, and through which one shapes and masters one's environment, but also one's own character, is itself somehow subordinate to something which makes that human freedom? Yeah, so he tries to develop the point that ultimately we have the quest to try and reach beyond ourselves as human beings. Now, the other point to note is that these basic goals, which Finnis has given, are they exhaustive? In other words, are there just 7 basic goals, or we can add to the list? Can we add to the list or not? So I want you to ponder that. And if you go and read his work, he has just a section, an exhaustive list. So if you go and read it, you'll be able to answer the question whether we can add to the list or we cannot add anything to the list of 7. Now, the 7 basic goals, which Finnis has told us, are combined with 9 principles of practical reasonableness. And what are these 9 principles of practical reasonableness? He lists them as follows. 1, the good of practical reasonableness structures the pursuit of goods. So it shapes one's participation in the other basic goods by guiding one's selection of projects, one's commitments, and what one does in order to carry them out. So that is one manifestation of the practical reasonableness. 2, a coherent plan of life. One ought to have a harmonious set of purposes as effective commitments. 3, no arbitrary preference among values. So when it comes to the 7 basic goods and so on, one ought not to omit or unreasonably exclude or exaggerate any of the basic human values. So we cannot say that sociability is more important than religion, or religion is more important than sociability, or aesthetic experience is more important than life, or life is more important than knowledge. Then 4, no arbitrary preference among persons. One should maintain impartiality in regard to others and their interests. 4, detachment and commitment. One should be both open-minded and committed to one's projects. So these are all part of the practical reasonableness. And 6, the limited relevance of consequence. That is to say that efficiency within reason. One must not squander opportunities through inefficiency. Action should be reasonably efficient. 7, respect for every basic value in every act. One should avoid acts that achieve nothing but damage or impede one or more of the basic forms of human good. 8, the requirements of the common good. One should act to advance the interests of one's community. So that is like the common good. And then 9, following one's conscience. One should not do what one feels should not be done. You must be true to your conscience. So anytime you are doing anything, if your conscience is against it, then you should listen to your conscience. So to John Finnis, the combination of the principles of practical reasonableness with the 7 basic goods leads to the immutable, that's unchangeable, and universal principles of natural law. So therefore, for him, natural law is the set of principles of practical reasonableness in ordering human life and human community. And it is the practical reasonable person who can grasp these basic values and the law's purpose in realizing them, who can rightly describe the law. So that is how Finnis develops his understanding of natural law. Now, before we leave natural law, let's look at some of the criticisms which have been leveled against natural law. First, scholars like David Hume would critique natural law on basis that knowledge which is not based on experience has no value. Natural law is supposed to be a priori reasoning. A priori is supposed to appeal to esoteric or metaphysical abstraction. So being metaphysical, according to critics such as David Hume, natural law precepts cannot be adequately demonstrated because it's metaphysical, it's not concrete, it's not grounded in experience. And for that matter, he and other scholars who mock the tendency of natural law to derive an ought from an is. And this attempt to derive an ought from an is totally meaningless. And they actually call it the naturalistic fallacy. So the naturalistic fallacy, which is leveled against natural law school, is an attempt to derive what ought to be something from what it is. Another critique is canvassed by Jeremy Bentham, and to him, the subjectivity of natural law is antithetical or is contrary to the concept of sovereignty. Now, later on, when we are discussing legal positivism, we talk about the Jeremy Bentham and how he develops the idea of sovereignty. The fact that the sovereign is not subject to any command, the uncommanded sovereign. Now, to Bentham, this subjectivity will lead to endless revolution, because when a man feels that the law lacks some criteria which is based on his conscience, he is thus impelled naturally to rise up against the law. So if you look at most of the scholars that we read, they will be teaching us that if the law is, for example, is unjust and so on, in some cases, it may be legitimate for you to disregard the law. The only caveat by some scholars like Thomas Aquinas will say that where you disobeying the law that you subjectively judges to be unjust is going to lead to greater chaos, then you need to obey, despite the fact that it appears to be unjust. Now, Alfred Ross also asserts that the principles of natural law were neither eternal nor immutable, as they have been used to argue either for or against any conceivable human endeavor. For example, slavery. Now, if you look at the literature on slavery, at some point, those who were doing the slavery and colonialism will tell us that they had a moral obligation to come and take other people that they perceive to be not properly developed human beings and so on, to go and subject them to training under the form of what? Slavery, under the form of imperialism and colonialism. Now, the arguments they use, if you examine them, seem to be grounded in some form of natural law thinking. Now, if that is the case, then how, in another breath, later on down the centuries, you come to tell us that by reason of our common humanity, there are certain rights and freedoms which are inherent in us and all of us, reminding you of the Universal Declaration of Human Rights, for example, that all of us are entitled to certain freedoms and so on. How can you say that? Are you not contradicting yourself? So that seems to be like the argument of scholars like Alfred Ross. Yeah, so we will draw the curtain down on our discussion of natural law this morning here.